Friends, we are starting now. Today is the 273rd Friday group meeting. The speaker is Naveen Pahwa, Senior Advocate, topmost Senior Advocate in this country. The today's topic is institutional arbitration under the State Work Contract Acts violates of principles of fair play, equality and impartiality being India's fundamental policy of independent arbitration. It's sir has chosen, is going to be. Now, sir, this is our 11th year, sir. So more than 17 lakhs viewers we have in our YouTube channel, that is our own Friday Group YouTube channel, and 38,000 subscribers we have. So we too have our own website also. So these are all going on. Now I request Pival Pettireddy will say a few words about today's speaker.
Thank you, sir. Senior Advocate Shri Naveen Pahwa ji graduated from Delhi University. He was a company secretary before he became a lawyer. He practiced for over 31 years before the Gujarat High Court. While being in Gujarat, he frequently appeared before this honorable court. Having undertaken a long and accomplished journey, sir has shifted his practice to this court since the past 3 years. We welcome you, sir.
Thank you. Excuse me.
Hi, good evening friends. It's a pleasure to be with all of you this evening to discuss on a topic which of course has been deliberated in many judgments in the recent past by this court. But there are some nuances which perhaps may require further deliberations and discussion. Just thought to place them before you by this presentation. I'm sure all of us are engaged in any arbitration proceedings. The first question which a lawyer would ask the litigant or the AOR as the case may be, who is the arbitrator? I'm sure this is the first. You're not concerned about the merits when you are engaged, right? You are concerned about the arbitrator. So this is the first question which I'm sure in a court of law you will ask who is the judge, which bench is the one where matter is listed, and arbitration, the first question is who is the arbitrator? Idea behind the question I'm sure is you want to understand whether the arbitrator is the one who is a man of independence, man of integrity, a man who has a reputation of being completely impartial. That's the suggestion which you're looking at, isn't it? And depending upon the name that you seek, you decide generally also the outcome and tell the client after having seen the merits to some extent. This is a system, right? Therefore, the importance and the emphasis in a proceeding of arbitration, which of late even the Parliament has been propagating quite loudly, is the independence and the impartiality of the arbitrator. If you go back to history, I'm sure we all would have some rural background, and we must have heard from our parents, ancestors about system of panchayats. So you had sarpanch or some elderly people or group of persons in the village whom you all would respect, right? And approach them for justice, which was generally understood to be a panchayat rule, panchayat decision, panchayat rule of law, and so on and so forth. The important part of such decision-making process was your trust in that individual or the body of individuals, right? So they were generally the elders or sarpanch, etc. This is what ultimately has been the focus in our Central Arbitration Act, 1996 Act, which we'll discuss a little in length shortly hereafter. Before that, before I take you to the Central Act, the Arbitration Act 1996 and certain state enactments, which are framed by some states, which have tried to oust the application of the Central Act and applied the local acts to resolve arbitration proceedings through their own manned arbitral tribunals. My focus would be to urge or submit that this concept or this establishments of the local works tribunals by some states is completely in violation of the purport of our constitution. And I will cite a judgment of this court, very interesting judgment of this court in 2024, where this court refers to a norm, a German norm, which is known as Grundnorm. And the court says that the Grundnorm, insofar as our India, our country is concerned, is the constitution. You cannot have any act, you cannot have any instrument, any agreement, any arrangement which violates the constitution. And the first pillar, which has a direct relationship with arbitration proceedings, is Article 14, and then of course Article 19. Now, having said this, as I said, the law on even the independence of the arbitration and arbitral tribunals has evolved gradually. If you go back to the first codified act in our country was the Act of 1940. I'm sure you would remember then, when we all would practice on arbitration matters. The award itself was not enforceable. It had to have a seal of the court, right? So once the award is made by an arbitrator or a tribunal, it had to go to a civil court, a trial court, and the trial court would be requested that please apply your seal to this award. So judicial mind was involved during those days to make an award enforceable, right? Then comes the 1996 Act. If you see the Act before the 2015 amendment, I'm sure you are aware that 15 is the time when the Parliament brought sweeping amendments in the new Act, and the focus was primarily on the independence of the arbitral tribunal on the one hand, and giving more finality to the award. So two things were to sort to be achieved. So as I said, in 1940, the award had to be applied to the court to make it a rule of the court. In the 1996 Act, it wasn't so. A change was brought in. But bear in mind, change was brought in first by Section 11, which stipulated that an arbitrator should possess some qualification. He must disclose that he is independent. He is not partial. Right? This was the requirement in Section 11. And then we had 12. Section 12, subsection 1, subsection 2, 3 provided for the continuous requirements of disclosure, both at the time of appointment and even thereafter. The law, as you all understand, in Section 12 said that there is an obligation on the arbitrator to keep disclosing if at all he becomes non-independent, not just at the time of appointment, but even thereafter, at every stage. No sooner there is any interest developed, he must disclose. That's a requirement. But unfortunately, I'm sure you would have noticed, we have Section 4 in the Arbitration Act. Section 4 is a waiver provision, which is a deemed waiver provision. This provision says, or rather it implies, and there are judgments on this point, that if you have accepted an arbitrator and you have accepted the proceedings of arbitrator at his end without any objection, although you know that he is not independent, then this is a deemed waiver. You cannot challenge the appointment subsequently. So the requirements of 11.8 12.1, 12.2, disclosure, etc., all became meaningless. Because disclosure notwithstanding, if you have participated, you have not raised objection, then you are waiving your right to challenge, is the principle which court evolved. Rarely court interfered. I don't think you would have ever seen that there was a challenge made to an appointment of an arbitrator 2 years down the line, 1 year down the line, on the ground that the man is not independent, the man is not partial, and court would have entertained. Hardly any case. They would have said, you participated, 6 months down the line, you come and challenge it, we will not entertain it. It's all with oblique motives. Right? So, notwithstanding the requirements of disclosure, you had 5th schedule, 4th schedule, so on and so forth, but all was meaningless because of the deemed waiver in section 4. Now, because of this problem, rather the provisions were not really suitably amended. I'm sure you also would recall that an award, when it was challenged in 34 court, there was a deemed stay, right? You are not required to make an application for stay of an award. So the practice was not by virtue of any provision of law, but practice which courts accepted in the entire country was, no sooner you challenge an award in the court of law, there was a deemed waiver. So long as 34 remains pending, the stay will continue. Then 37, stay will continue, so on and so forth. This was the practice. So there's no finality to the award on the one hand. Two, the challenge to an arbitrator who seemingly in some cases was biased, not partial, not impartial, was not sustained. So there was a serious problem in really enforcing this act. Now, with this intent in mind comes the 2015 amendment. You are aware that there are two broad changes. One change was giving rather wings to a litigant to take a call whether, notwithstanding the disclosure about lack of independence and impartiality, do you want to accept him as an arbitrator? The choice was given to you by saying, the law said 12.5 was brought in force with a proviso, and the law said that as against deemed waiver in section 4, 12.5, the man will become ineligible, the arbitrator will be ineligible if he gets into any disqualification as defined in 5th schedule or 7th schedule. A long list is mentioned in the two schedules. And schedules, I'm sure you have seen, or I just tell you in one word, any interest with which arbitrator is connected would make him disqualified, is the present law. Any interest in the subject matter, in the parties, etc., he will stand disqualified automatically. 12.5 says he becomes ineligible. And the judgments have come, not one, series of judgments. He becomes ineligible from inception. It's like void ab initio, nullity. The appointment is nullity, is what the Supreme Court has said not once, 10 times. And Supreme Court has gone thus far by saying that even if this person, this arbitrator, renders an award, final award, it is non-est. Just imagine, the Supreme Court, while interpreting 12.5, the proviso, has gone to the extent of saying that stage of proceedings is immaterial. I have seen judgments where in 37, can you imagine, 34 award is made, award is challenged, sustained. 37 stage, people have challenged it and they are quashed. Award is quashed. Because Supreme Court says, this is void ab initio, it's nullity, stillborn child. If you are able to show the man was ineligible from day one or even subsequently, he caught up the disqualification, he goes home, not from today, from yesterday. This is the law which the Parliament brought in, and the language is so strict, and Supreme Court, to our advantage, has interpreted very strictly, because the object was that our country wants now that we should have an arbitrator friendly environment. There is a concept of equality. Equality would mean that both persons have the equal right to have an independent arbitrator, not just one person. You have a right. In fact, the Supreme Court has borrowed the concept of Article 14 into Arbitration Act and says that the right of equality under Article 14 can be borrowed into in Section 12, subsection 5, so as to bring in the principle of equality, the principle of fairness, and the principle of impartiality. In other words, the rule of natural justice is brought in. Just imagine the encompass which the Supreme Court has given to this principle as embodied in Section 12, subsection 5. We have a series of judgments which have taken the view that this is absolute nullity. And I have seen judgment, I'm sure you would have also come across judgments where the officials of the company have appointed a former judge of this court, Supreme Court, and the appointments are set aside. Just imagine. They have gone to the stage of receiving statement of claim, defense, evidence led. At that stage, the Supreme Court says that since the person appointing was disqualified, the person appointed consequently gets disqualified. That's the law. So you've gone to that extent. A court says that we are not concerned here with the objectivity or the reputation or the respect of the nominee of the appointing authority. He could be a man of high respect, but he becomes ineligible because he is appointed by a person who was not competent in law to appoint him. Please imagine, this is the strength of the judicial pronouncements on the subject. The court says that if the building, the structure is bad, it has to be demolished. The phrase used by Supreme Court is this: just demolish it. It has to go from inception. There can't be a plinth also. Everything has to collapse. So this is the extent to which 12.5 is now being considered by our court. In fact, the court says to the extent that no sooner you find the man suffers disqualification, his mandate automatically terminates. You are not supposed to challenge it also. You are not supposed to go to arbitrator and tell him that you have no authority in law. Just inform him that, sir, you are disqualified. And he has to tell or accept that the mandate gets terminated automatically by operation of law. If it does not do, then you have to go to the court of law. Otherwise, the law Supreme Court judgment says that the mandate terminates automatically. Being this in mind, now let us examine the legality and the veracity of the local acts. It's so unfortunate that on the one hand, we, the Parliament, propagates that we should have independence in arbitral proceedings because the world is watching. We are into global arena where you have large number of arbitrations, domestic, international, where you have international players participating. So we have followed, as you know, model law. General Assembly wanted India and other countries to accept it. We accept the suggestion. In fact, our preamble says so. Therefore, we should respect and make sure that our arbitrators are completely neutral. They are completely independent, completely impartial. As against this, there are some state acts which clearly bifurcate some contracts out of the purview of the common arbitration acts, and they have formed or established local acts. One such act which I just went through was the Gujarat Act. We have Gujarat Works Contract Act. Now this local act, you will be surprised to note, provides for a provision enabling the government, the state government, to constitute the tribunal, manned by a chairperson who will be of the rank of a sitting or a former High Court judge, and a secretary to the government, and third, a chief engineer of the government. Now please imagine two things. One, although you have a High Court judge, a former High Court judge as chairperson, but please consider the appointing authority is the state government. I just mentioned to you about a judgment of Supreme Court where this court says that even if somebody appoints a Supreme Court judge as an arbitrator, we are not here to examine his objectivity, his reputation, his respect, because the appointing authority is ineligible by virtue of 12.5, because you have no power. If you start appointing persons of your choice, how do you retain the concept of equality, right? As the Supreme Court says that even if the arbitrator is a retired Supreme Court judge, the appointment is vitiated, it was set aside. Here, the government is a litigating party because it talks about the contracts in which the government, its department or its government companies are litigants on the one hand and the contracts on the other hand. The government appoints an arbitral tribunal. It appoints the judge of the High Court, maybe so, as the chairperson, and two other officers as the members. Now these persons constitute arbitral tribunal, who will decide what? The claims of the contractor against the government body, against the government company, or vice versa. Just imagine what kind of justice are we looking at. And you'll be surprised to note, not just this enactment, other state enactments also of similar nature provide salaries are being paid by the government to the chairperson of this tribunal and the members of this tribunal. I'm sure you are aware that High Court judges and Supreme Court judges are paid from the fund, not by any government, right? To maintain independence of the judiciary. Here, the salary is paid by the government. Rules with regard to their service conditions are framed by the government. So you are paid by the government, your conditions of service are determined by the government, and you are expected to give justice to a contractor. It's absolutely not possible. And interestingly, all these enactments, I just saw a few of them, contain a provision, very interestingly, and the provision says that the local act, to the extent of inconsistency with Central 1996 Act, will prevail. Just imagine, a local act will override the central law in case of inconsistency. And these laws are being applied. And unfortunately, some decision of this Honorable Court where such local acts have been upheld. How can you, just imagine, in an era of complete independence, judicial impartiality, an act providing for appointment by the state, salary by the state, service conditions by the state, rules by the state, and saying in case of inconsistency this law will apply. All the principles of precedence are sent in the background, completely ignored. So giving precedence to a local act vis-a-vis a central law, which is of course then concurrent list, but nevertheless you cannot really say that in the event of inconsistency local act will prevail over the central law. This is what has been done. At this stage, I was doing research and I found the judgment of Supreme Court, very good judgment, which is a judgment of 2024 named Lombardi Engineering Limited. Now this judgment, interestingly, scope was limited to challenge to an arbitration agreement which stipulated deposit of 7% of the claim amount before you can seek appointment of arbitrator. So in an arbitration agreement, there was stipulation that unless you deposit 7% of the claim amount, you cannot seek appointment of an arbitrator. This was the clause. 11 was filed. In 11, this issue was raised and challenge was maintained on this. You can't have this kind of stipulation because it takes away your right of arbitration. This court examined the law vis-a-vis 12 subsection 5, the amendment of 2015, the judgments of this Honorable Court extensively and eventually said that no, this is not permissible, etc., etc. But it said very interestingly, in that case it was filed. The Supreme Court says that if the contract is in violation of the Constitution, you're not supposed to file a writ petition. You can raise this issue even in level proceedings. Vidyadrol, I'm sure you must have seen, says that in 11 proceedings, you only have to show existence of an arbitration agreement. Nothing more, nothing less. Was the first judgment of Supreme Court and then followed it with the role and so many judgments. But this judgment takes a view that no, we cannot shut our eyes to the contract which seemingly is against the Constitution. If it is against the Constitution, 11 court is obliged to examine that objection, and if that objection is sustained, set aside and appoint the arbitral tribunal, minus this requirement, is the view taken in this judgment only by the Supreme Court. Very interestingly, the Supreme Court in this judgment brings, as I said, the concept of Grand Norm. It's a German concept, and there's an author, Kelsen, in Germany. He brought this theory known as Kelsen's pure theory of law, and he said that we all are to be governed by a grand norm. So grand norm is like a pyramid. On the top you have grand norm, a norm which is grand. You know, the concept is a grand norm, the grand law. This court borrows the concept and says, in India, the grand norm is the Constitution, our Constitution of India. So when you apply arbitration, when you want to invoke arbitration, when you want to seek appointment of an arbitrator, keep in mind the grand norm. This is a mandate given by this court to persons seeking appointment of an arbitrator, and to the law and to the courts which are under an obligation to appoint an arbitrator. The court therefore obliges them that don't shut your eyes to anything beyond an agreement. Please examine. If the agreement is not right, is against the Constitution, please consider it, examine it, adjudicate it. This is what the Supreme Court says. And very interestingly, there are some paragraphs of which so beautifully worded. The Supreme Court says that in the context of arbitration agreement, you have to have layers one has to keep in mind. He says, first, please keep in mind the Constitution of India. So when you invoke section 11, this court says that keep in mind the Constitution of India, the first parameter. Second, the act concerned, could be the Central Act or any other law, any other act where under you want to seek an appointment of arbitrator. Of course, in our country we only have Central Act of 1996. Third, the arbitration agreement. Please consider three things before you make an appointment or don't make an appointment of an arbitrator. And then says, when you examine the agreement, first see section 7 of the 1996 Act. You are aware of parameters of section 7. Any other provisions of the Act, so it could be 12.5, right, 12.2, etc. And again the Constitution. So much of emphasis is given to the Constitution. So the court says that whenever you are approached, the courts in our country, they have to keep in mind this grand norm. And the Supreme Court says this is the operation of law. When you are applying your mind to an appointment of an arbitrator. So please bear in mind this operation of law and then proceed whether you have to appoint an arbitrator or not. Now I'm sure if one has to apply the Constitution, you can't ignore Article 14. And if the Supreme Court says apply Article 14 in section 11, everything is open. The concept that look at the agreement only and then shut your eyes is gone. You have to examine, you have to keep in mind Article 14 or Article 19, because that's our grand norm. That's our constitution. You can't do any proceedings. You can't do anything unless it is consistent with our constitution. I think this judgment reminded me that we must not, as lawyers, lose sight of our constitution. That is our, what is that known as the basic edifice on which we survive as professionals, whether we are in a professional capacity or even otherwise. So we can't really, and we are expected to know our constitution as lawyers. So we can't really lose sight of this. So I would request this judgment, I'm sure, warrants reference by all of us. And look at it, so beautifully written. The court really has done a lot of pain in giving this judgment to all of us, and which enlarges the scope of, I would say, our evaluation in the matters of arbitration. And as we all say, the law is really growing. It grows every day. And as lawyers, we all learn from each other every day. Therefore, we are also known as students of law rather than the lawyers. Having said this, this is what I thought I would share with you this evening. Thank you so much. Anything which I can assist, say, please.
Thank you very much, sir. Very nicely elaborated through judgments and all. Oral arbitration. Really grateful to you. Thank you very much. Now I request Rahul Sharma will give vote of thanks.
Seshu sir has given me the privilege of delivering the vote of thanks, and I'm deeply grateful for this honor. On behalf of my respected seniors and esteemed colleagues, I would like to thank Senior Advocate Naveen Pahwa sir for sharing his thoughts, experiences and knowledge about today's topic. And our question in today's topic is institutional arbitration under the State Work Contract Act's violation of principle of fair play, equality, impartiality being India's fundamental policy of independent arbitration. So you enlightened us with the fact that how the Honorable Supreme Court of India has reiterated the fact that the Constitution of India under Article 14 is the grand norm of arbitration in India, as said by a German thinker, Kelsen, that the Constitution should be the grand norm, the sacrosanct in arbitration. And how the appointment under Section 11 of the Arbitration Conciliation Act 1996 in India should be done according to Article 14, and which says about equality and independence of the arbitrator, and myriad points that you shared, sir. And it is such a privilege to listen to such a stalwart on the subject like this, sir. And on behalf of the Friday Group members, I would like to thank everyone for their attendance and patient hearing. And thank you again, sir, for enlightening us. Thank you.
Thank you very much, Rahul. Now we will questions. Any questions?
I have questions.
Yes, sir.
You can answer because you are an expert in arbitration.